live, sir.
Okay, right.
Yes, sir. Raghavendra, sir, you can start.
Yes.
Right, let him come.
No problem, Raghavendra, you can start.
Good evening, one and all. Welcome to, once again, the first web series. Web series conducted by Janata Education Society along with Vivekananda College of Law and its alumni. I welcome one and all present here. Today's deliberations going to be on the labor law, the long march of labor law, especially the pivot or persevere, the long march of change in labor laws. Today's session will be conducted by one of our alumni, my close friend, Mr. Ravi, Mr M R Ravishankar. We're just waiting for him. Yes, there we are. So, welcome, Mr. Ravi.
Thank you, sir.
So, I take this opportunity to welcome Mr. Ravi, and may I request Professor Kembegoda, sir, Principal, Vivekananda College of Law, and ex officio Chairman, Alumni Association of Vivekananda College of Law, to introduce today's speaker. Please, sir, over to you.
Thank you, Raghavendra. Today's guest speaker, Shri M R Ravishankar ji, all the invitees, respected academics, student friends, colleagues. As you all know, Janata Education Society's Vivekananda College of Law has organized this webinar series on various topics in coordination with our Alumni Association as an IQAC initiative. I take this opportunity to thank the office bearers of my Alumni Association for extending their cooperation in organizing this program. Friends, today we have amidst us Shri M R Ravishankar, an alumnus of Vivekananda College of Law of 1998 batch. It's my privilege to introduce him to all of you. Shri M R Ravishankar enrolled with the Tamil Nadu Bar Council as an advocate in 1998, started his practice as a junior advocate with Mr. V. Varadarajan, a senior advocate at Vellore. In 1999, he joined his father, Mr. M R Ramanan, and started his own firm, Mrs. M R Ramanan and Associates, a law firm at Vellore, as its partner. He is from a lawyer's family. He is practicing with his father now in his new firm, and he has conducted more than 3,000 litigations covering criminal, civil, consumer, and labor cases. Ravishankar, I know your professional accomplishments are more, but due to paucity of time, yes, I take only few important achievements of him. He was appointed as a special public prosecutor for Government of Tamil Nadu to conduct many criminal cases on behalf of Government of Tamil Nadu. And he was appointed as a special counsel for Tamil Nadu Civil Supplies Corporation for proving serious fraud committed in essential commodities procurement and distribution in the state. He successfully handled strikes in various types of industries, have thorough exposure in core industrial relations issues, successfully implemented contract labor system in industries. What impresses me a lot is that he is a visiting faculty to many institutions. He has that academic fervor in him. He is a visiting faculty since 2001 at the Christian Medical College and Hospital, Vellore, and he is a professional professor of practice at VIT Business School teaching business laws. He is a visiting faculty at VIT Technology Business Incubator for Entrepreneurship Development Program, member of Internal Quality Assessment Cell, that is IQAC at VIT, member of Institutional Ethical Committee for Studies on Human Subjects at VIT, legal researcher for book titled Industrial Relations in India, a Practitioner's Handbook, published by Macroil. Papers published, The 33 Conundrum, whether violation of Section 33 clothes a dismissed workman with an automatic right of reinstatement with consequential benefits, the Law and Practice of Industrial Disputes Act, published in LexisNexis, and one more article, Contrarian Activism, the Law of Maintenance, the Jeopardy of a Young Adult Son, and he spoke on militant trade unionism and its status in Tamil Nadu at the Employers Federation in South India, that is Chennai, and he spoke on several topics, that is employment in consumer electronics manufacturing, spoke on employment laws at various seminars organized by various organizations, and his clientele are prominently institutional clients. He is advising them in litigation, non-litigation, and in-house support, retainer, and legal research. To name a few, government and quasi-judicial and cooperatives, and also educational and medical, that is Christian Medical College, VIT University, Vellore, and engineering, TVS group of companies, Murugappa group of companies, and ArcelorMittal Dham Processing Limited, and etc. There are many other industries in chemicals, pharmaceutical industries, and he is an advisor to Measures Global Calcium Limited, Bengaluru, and there are a good number of pharmaceutical companies, cement companies, leather company, agrofinance company. And as I said already, his father, he himself, and his wife is also an advocate. She is teaching at the Academy for Prisons and Correctional Administration, Vellore, and she is an independent member of Internal Complaints Committee of various organizations under the Prevention of Sexual Harassment of Women in Workplace, Prevention, Prohibition, and Redressal Act 2013. And Ravishankar, I'm really happy to have you on this occasion to speak on this specialized subject, because this field, that is the labor law, is at crossroads now, because the NDA government's decision to codify all these legislations into three has opened the Pandora box, and it has resulted in introducing new changes in the field. And you are an expert perhaps to speak on this particular subject, and thank you very much for joining us today to deliver a special lecture on this important topic. On behalf of Janata Education Society's Vivekananda College of Law and our Alumni Association, I take pleasure to welcome you on this occasion, Ravishankar. And we have amidst us the office bearers of our Bangalore Bar Association, particularly Shri Shivmurthy, treasurer of our Advocate Association, professors, Professor Sudesh, Professor Mohan Rao Balla, Professor K. Shuprasad, and Shri Harish, one who support us in all our programs and advocate, and many legal practitioners have joined here. I take opportunity to welcome all of you friends, and I take pleasure to welcome the office bearers of Janata Education Society, our managing committee members, particularly Shri Lakshmi Manohar and Shrimati Indira Gopala Krishna, and our Janata Education Society member Shrimati Bindu. They have participated here, Bindu Mayana, Yes, I welcome all of you to this webinar. And we have today students from various other institutions, including my own students. They have joined here. And I thank each one of you for joining. And also, I welcome my colleagues, students, friends. I welcome one and all. Thank you. Thank you, one and all. Thank you.
Thank you, sir. Thank you so much. Before we kickstart the session, just remind you, please post your questions in the chat box. And also there are some, those who want the certificate, please fill the form that will be posted in the chat box. So let us go with Mr. Ravi. Please, Ravi, session is yours. You can start, sir.
Yes.
If you want to share the screen, you can do that also, if you have a presentation, PPT.
Raghavendra, is my screen visible?
Yes, yes, yes. It's visible, please.
Good evening, sir. Good evening, all the honorable guests. This is not going to be a lecture session and all that. I'm always conversational as far as my ability to speak is concerned. You will find the topic, it is not classically legal in the sense. Again, my topic is also conversational. During the introduction, our principal said we are at the crossroads. Let's imagine crossroads is like, we do not know which direction to take. That's where we stumble upon, and then to think for some time, which side are we supposed to take? And that is what I call it as pivoting. You will find whether we are to be struck with the same place or which side to move about and things like that. Historically speaking, the tagline is also loaded in the sense, the long march. It is not a commonly used expression. Historically, if you will find, it starts with the Chinese Cultural Revolution and goes back in history to the long march started by Mao Zedong. He traveled across the country and then wanted to bring in a sort of a new wave of change culturally, and then use that towards a direction to move ahead as far as the country is concerned. So that was the importance in the long march itself, and it's got a very big history to speak about. I use that as a comparison that today, after from 1947, we are standing in a place where we have to decide whether we want to be struck in the same set of legal framework or we want to pivot. The result of the pivot by itself could be anything. It has to be time tested. But the idea that we have to move ahead is more important than sitting in one place. So whether to persevere all this time that what has happened, or should we need a change? Not for the sake of change. So there has to be justifiability in all the actions. And therefore, we are at that crossroad to decide whether this is going to be necessary for us in the first place and whether we are going to take this direction in change. Now, since I'm going to confine myself only to the changes that they are likely to take place in all the labor laws, not all the social changes that they are likely to bring about. Now, any law for that matter, to understand law on two different aspects. One is the macro purpose of the law itself. The other is the micro purpose of the law, which is a practitioner's point of view. Now, we need a lot of sense of imagination as far as a practitioner is concerned. It is not sufficient that we read the letter of law. We need a practical perspective as such. And therefore, a lot of imagination is necessary as to how this is going to build about and what kind of implications are going to come about in any changes of law itself. Therefore, our ability to reason, take for example, a teacher in a classroom starts putting questions at the students. We can keep answering those questions by our reason, a common sense point of view and a legal sense point of view. These are two different, entirely different things. Now, once we start practicing, we will get to know what is the basic difference between a legal perspective and a common man's perspective. Now, we will always be flooded with that difference of opinion even within ourselves when so many things happen around us. One at the standpoint of the common man, the other at the rigor of the legal implication. For an example, you will find any number of times in newspapers, kidnapping is the word that is used. Now, definition as the legal rigor goes, only a kid can be kidnapped. An adult by law, that is called as an offense of abduction. Now, fundamentally, that runs down to our ability to understand things as a recipient with a legal rigor, which is distinct from that of a common man. Now, unless that rigor is set in as a practitioner, we always will be at conflict, is my humble opinion on that. Therefore, a lot of imagination is necessary so that we keep asking questions. And the more we ask questions, we will clarify to ourselves, which is relevant in decision making itself. You will find teachers of law will always tell you what is the sources of all these laws, primarily in respect of our country. The major legislation, you know, are pre-independence era, which means our laws were fundamentally enacted in the British Parliament. Now, the Government of India Act came in 1915, where the British Parliament was empowered to bring in laws as such in respect of the New Age phenomenon. All these law commissions preceded, and primarily you will find they took into factors the customs and usage as far as our country is concerned, and then loaded that with the principles of equity, which is again on the vision of the British citizens. So principles of equity in our cultural domain was entirely different from those of the British. And therefore, always you will find there is a conflict in understanding the legal system itself. Now, in 1947 and subsequently in 1950, we adopted the Constitution, where Article 372(1) provides all the laws in force within the territory before the commencement shall continue in force. Therefore, as a student of law, always we have this conflict. Why is that 1860 Indian Penal Code is enacted by the British Parliament, but 1860, the same law we still follow in 2021? By virtue of Article 372(1), we are to follow, and therefore we are following. But what has happened in between? All these years took by, we have matured as a constituent of this country. A lot of changes have taken place, both at the social level, the customs and usage. Everything has changed. When I was in college in 1994 to 1988, today things have entirely started being different, and our understanding therefore grows together. There is a fundamental principle of rule that we follow in interpreting statutes. When we read legislations, it is necessary that we adopt what is called as the literal rule of interpretation. Meaning, just read the sentence and see what it actually gives out. And whenever there is a misconception or a misunderstanding in its application alone, then comes the help or aid by other constructions, namely by looking at citations of judgments or how the judges interpreted them or ruled in those matters. Now, you will find this has stand against right from 1973. For the purpose of citation, I'm giving you this. And even until 2014 in Lalita Kumari case, any criminal law practicing advocate would definitely subscribe to this. So we go by the definition. There, the challenge always is our ability in understanding English. To my considered opinion, our abilities are limited. We are good at understanding because most of us, our brains work in our mother tongue. Therefore, the ability to understand these legal mechanisms is always fair for us when we try to convert them into or translate them into our own mother tongue and then look at it as to how they replicate. Now, that helps us in understanding or interpreting any statutes itself. Now, across various jurisdictions in the world, there are different types of legal mechanisms. As far as our country is concerned, we adopt the common law system, as well as it is called as adversarial judicial system. Meaning, when you want relief, you go and prove yourself. You don't expect the other party to disprove it. So that is why it is called as adversary. Now, but however, it is distinct as far as our country is concerned that there is always even academic books written or practitioners' books written, calling it as law and practice. Then naturally, the question will be, why would you say that when law is there, that is what we are supposed to practice? But that's not the case. As to how this is evolved, and the root of the matter will always go to our ability to understand the English language as such. And that is why it is necessary that books are written on law and practice. And this is the only jurisdiction. I have not found, at least in many other countries, that any book being written as law and practice. So all that comes around from the interpretation of statutes. Now, this crossroads that Sir spoke about and the necessity that we have to decide on changing was felt by the Parliament over time, and they consolidated all the labor laws. There are number of labor laws that, as we keep counting, my last count ran into about 99 laws. I couldn't touch the 100th one. Now, it was felt that this is too many things to be read about and understood, and most of the times even the Parliament fails to understand why is that there are so many laws. So they felt it necessary to consolidate all these things based on all the changes that is effected over time, and therefore the reform was necessary. Historically speaking, we will find, as far as our parliamentary mechanism is concerned, any law that is made or the judicial system mechanism is concerned, any judgment that is delivered, it always has a huge impact on the society. Now, the impact could be based on substantive rights of parties, it could be procedural rights, and then there could be social implications, and then there are economic implications always in any of these changes, either if it is going to be a legislation changes or judicial pronouncement which pivots the legal position. Now, there are individual liberties that are affected and are social liberties which will also be affected. Now, any law reform will take into consideration all these things, and then is it necessary to bring in the change or not will be the decisive factor. Now, as far as confining myself to the industrial relations code alone, you will find the legislative roadmap was like this. 19th September 2020, it was introduced in the Parliament or the Lok Sabha, and then on 22nd of September, it was passed. I am to remind you, this is the second code. The first code itself was the Code of Wages, which came to be passed in 2019 itself. And then also to remind you, this code, though has been enacted by the Parliament, it is not still brought into effect. So effective date is not yet notified. Now, this acts, they attempt to codify number of laws, as I said, and consolidate them. You will find the Industrial Relations Code deals with 3 previous laws, namely the Trade Unions Act, the Industrial Employment Standing Orders Act, as well as the Industrial Disputes Act. Now, while learning labor law, they will always tell you that the Industrial Employment Standing Orders Act and the Disputes Act are sister enactments. One is dependent on the other. Therefore, these are the three laws which is codified as far as Industrial Relations Code is concerned. Now, there are substantive changes, meaning substantive rights are affected, and there are also procedural changes because of this amendment. Now, I am going to touch base only on few changes which are likely to affect our day-to-day practice, and I'm not going to speak about every change or every amendment that is brought. Now, you will find as any law is concerned, Section 2 has all the definitive terms. Herein, you will find the expression employer is amended by introducing a small expression called as or on behalf of any person. Now, please see the English language. It says it means who employs, whether directly or through any person, but then subserviently adds one more expression to say or on behalf of any person. Meaning, if I engage an intermediary to employ an employee, I'm still defined to be the employer. Now, this add-on portion was not there in the previous act or the existing act, but the Amendment Act brings in this change. Now, the next change would be fixed term employment. As of today, we are concerned, there is no expression called as fixed term employment, which is used legislatively. You will find categories of employment being used in the Industrial Employment Standing Orders Act, which will usually say as to who is a trainee. There are definitions given. Who is a permanent employee or permanent worker. It says who is a probationer. And it also prescribes if there is a probation period, what should be the probation period. Now, these are all provided as far as the model standing orders is concerned, which is a state enactment to supplement the act itself. Now, however, Industrial Disputes Act by itself does not define any of these expressions. Now, newly in the code, this expression fixed term employment is introduced. Now, while introducing this change, they have also brought in two ways to balance it out. One is to allow the employer to use such an expression for the purpose of appointment, but simultaneously on the counterbalance, they have also enshrined certain rights which are available to workmen if appointed as a fixed term employment. Now, misuse is forethought, and therefore they have brought in such change. Now, you will find, I'm not going to repeat the definition itself, you can find on the screen. It only means engagement of a worker on the basis of a written contract for a fixed period. Now, the rider by judicial interpretation earlier available to us gives us an indication. It is the work which has to be fixed and not the worker. Meaning the term employment, the employment has to be time bound, that it starts and completes. For example, take a construction project. The project itself starts and the employment comes to an end the moment the contract of delivering that building completes. And therefore, it is needless to say that I can't argue as an employee, irrespective of whether there is a project available or not, the company has to keep constructing. So therefore, there you will find the binding factor is the employment comes to an end with that project. Therefore, the tenure of employment is on the project rather than the employee. So that is the judicial interpretation as far as today is concerned. Now, introduction of this will lead again to several interpretations in the further course. But however, the matter stands that it is balanced out, one, giving the right of employer to avail such a service, and also a counterbalance by providing monetary relief. Now, the expression industry, you will find three components to be remembered always as to decide whether something is an industry or not. Now, the financing part of it has no role to play in it. Any systematic activity, rule number one. Cooperation between employer and worker, rule number two. For production and supply of distribution of goods and services, rule number three. Whether this is an industry, if the employee is paid wages or not, is never the question. Even on a honorary position, still an establishment rendering production or service of supply will still amount to industry. Judicial interpretations have gone by right from the Bengaluru Water Supply Sewerage Board case until today. That's now these three components is supplemented by one expression in between, whether such worker is employed by such employer directly or through an agency. Suppose I say I have an establishment on a contractual basis. The entire production is carried out by a contractor. Even then, it will still amount to be called as an industry. Now, the new age phenomena as it develops, the law takes course, and it is necessary to find such gaps being plugged by these amendments itself. Now, therefore, it was found necessary to include the new definition. Now, while doing so, they have also thought it fit that there should be an exclusion part where specifically these kinds of organizations are excluded. Institutions owned and managed by organizations which are charitable. Domestic service. Today, as far as we are concerned, even housekeeping services amount to industry. That's the classic definition that is used. Now, this amendment specifically excludes domestic service from the definition of industry. Now, then the major change as far as rights of workmen is concerned, this is the place where all the trade unions have thought it fit that there is enough and more cause for them to agitate and oppose this amendment to be brought up. Now, strike has a definition which is a common parlance that is used. Strike means refusal to work. Now, the legal definition is concerted refusal to work. It is not one man, it is more than one man joining together and deciding to refuse to work. Now, that is what is the legal definition of it is also, but except that this amendment tries to bring in that even if a group of workmen join together, which is 50% of the entire workforce, and apply for casual leave, that amounts to strike as far as the amended definition is concerned. Now, law has also brought in a rider saying, if you are to go on a strike, you have a right to go on a strike, but except that you put the employer on notice with a 60-day prior notice. And then the secondary benchmarking is that after issuance of notice, for whatever be the cause, within 14 days of such notice, you can't commence the strike. Now, unions are opposing this by stating 60 days prior notice means that the employer has all the time during which they can manipulate things and effectively bring down the strike strength itself and then to play havoc in the workers' rights. Therefore, they find that to be the cause for opposing the 60-day period. But look at the other side of it. Now, you will find the new age mechanism of alternate dispute resolution. ADR is a big focus as far as judiciary is concerned today. They find, I think, except for offenses under the Indian Penal Code, courts are today open to looking at a possibility of settlement in every other matter. You will find the CPC has an enshrined provision which mandates that the matter has to be sent for resolution first before even a trial commences. Now, such ADR mechanism you will find even as early as 1947, the industrial disputes had an institutional mechanism for conciliation. Now, you all know about the Arbitration and Conciliation Act. Now, all the focus for the learning is only towards the Arbitration Act. This Conciliation Act as a mechanism is very less spoken about, but you will find Industrial Disputes Act are, as early as 1947 felt it necessary that there should be an institutional mechanism for conciliation and dispute resolution. Now look at this point, that namely when there is a 60-day prior notice, there is always this possibility of the matter being referred for conciliation. And then there is a possibility of resolution of this dispute during the conciliation. And the need for going on strike itself could be mitigated. That is the cause from the legislative point of view as to why there should be a 2-month window before any strike is brought in itself. Now, strike has huge impact. It has a social impact, meaning strike in one establishment can fall out to other places. And it has a huge economic impact, not only on an establishment basis, but on the industry at large, and therefore the economic conditions of the country itself. And therefore, it is necessary that such a mechanism is evolved for the purpose of getting into a conciliation mechanism and justification for the time of notice itself. Now, the present Act mandates and classifies certain establishments defined as public utility service, where the state government has the right of notifying certain establishments as public utility service. Now, this is not to be misconstrued to those with the delivery of milk, which is public essential service. So this is not that. Now, as far as Tamil Nadu state government is concerned, even automobile manufacturing is declared as a public utility service. Therefore, the government has its own mechanism because the Act empowers the government to notify certain establishments as public utility service. Now, there is a prohibition. This is to be read from section 22 to 24 of the Industrial Disputes Act 1947, which provides as to if a strike is to be announced in a public utility service, there shall be notice, and there is a prohibition on going on strike if a conciliation commences. Now, such a definition has been done away with as far as the new act is, new code is concerned, and therefore this empowerment of the state government to notify certain establishments as public utility service will not happen henceforth. The right between public utility service as other establishments are concerned, they are going to be neutral. Now, as far as the definition of wages are concerned, these are the rights of the workers that I'm talking about. Wages definition even today has two components. One is the inclusion part, the other is the exclusion part. Inclusion part, they have not touched any change at all. They have retained what is the definition of wages as earlier. All remuneration. I always use one thumb rule. I still remember what Professor Billappa taught us. I'm talking about 1995 when he was teaching us IPC. Read the section. Even in the recent lecture he gives, please see the words that is used. That is the concern for us, and that will give us to understand the purport and the meaning of the section itself. Wages means all remuneration. Finished. So whatever be the title you're going to call that or the nomenclature you're going to give it with, all remuneration means wage. Whether such wages is for allowances, by whatnot, basic dearness allowance, retaining allowance, call it whatnot. It will amount to wages is the definition, existing definition. Now, the exclusion part of it has certain aspects. Namely, if it is a bonus, it does not amount to wages. Value of house accommodation. Huge water has flown in with this expressions debate itself, the judicial pronouncement. House rent allowance is not the same as value of house accommodation. These are two different expressions used. Conveyance allowance. This is the existing exclusion part of it. But then they have again added some more exclusions in the form of adding remuneration payable under an award. If there is a judgment rendered in a case or a settlement entered in a case, that does not amount to wages, overtime allowance, commission, gratuity, retrenchment compensation. These are excluded from the definition of wages as far as the new code is concerned. Now, again, that leads us to a confusion with all those expressions that is used. Sir, you are going to list out 10 different things as inclusion part and 10 different things as exclusion part. Now, how is somebody going to know? How are we to calculate these things? Again, the new code, when the framers framed this, has thought that anyway, we lawyers will come into play. We will be able to argue using all these English definitions versus the legal definitions and bring out new changes, load them if possible in favor of the employer. Now, considering that predicament, it was thought it fit that the calculation of wages has to be specifically provided for. And please see, this is how the entire definition is new as far as the code is concerned. If any payment made, meaning basic wages, dearness allowance, or retaining allowance, if it is exceeding 1/2 of the total, they say the other half, by what not are you going to name that as? Give it whatever new nomenclature. Use the English dictionary and start giving us all possible names concerned. Even then, the remaining part of it will still be added for the purpose of calculating wages. So, thumb rule is total wage packet divided by 2 And if the other components are in excess of 50%, they will automatically be added to the definition of basic wages. So such protection is provided for. On one side, again, please see a leverage is given to the employer, but corresponding weight is also given in favor of the workers. And then equal wages of all genders is added. Now, again, it was thought, the moment we are going to make all these calculation mechanisms, employers are going to find alternative methods to get against it. I'm not talking about all employers, unscrupulous employers. Now, there they find again a benchmarking. Now, if what is given to the workers, 15% is required. In excess of there, again, those value will also form part of the wages itself. Now, certain rights are given to trade unions. As I said, the Trade Unions Act is going to be wound up, and the new code will take into its shoes. Certain restrictions are given as far as formation of a trade union is concerned. And there are tribunals which is going to provide for the purpose of registration of this trade union. And then new expression called as negotiating union or negotiating council is used when there are multiple unions in a particular organization. You will find more than one union always having a loggerhead interest with other unions. And therefore, there is always a dispute ensuing because of non-agreement by amongst the unions. Therefore, it was found necessary that something called as the negotiating council has to be brought into place. And the participatory mechanism of the council selection itself, benchmarking is given. These are all new to the Industrial Relations Code, which is not there even in the previous, neither in the Industrial Disputes Act nor in the Trade Unions Act. So these are new changes that is brought. Now, then you will find one classic change that has been brought in is the existing mechanism is concerned. As far as Standing Orders Act or the Industrial Disputes Act, there is no mandatory provision which says a disciplinary action or a domestic inquiry, which we usually call it as, has to be conducted before imposing punishment on an employee. It only broadly indicates saying, using the principle of adi alteram partem, hear the man before you punish. The source of power itself comes from Article 311, where government employees are concerned, such a mechanism is provided for. Now, as far as private employment is concerned, the only thumb rule that came in for the purpose of conducting domestic inquiry or providing that to be as a mandatory exercise came out of only judicial interpretation. What we otherwise famously called as the Firestone and Rubber case. 1974 Supreme Court. The law was laid down by the Supreme Court by virtue of Article 141 of the Constitution. We still follow that to be the thumb rule as far as any disciplinary action is concerned. So unless a domestic inquiry is conducted, you can't punish. And if you punish, it has certain consequences. Now, that openness or the need for the judicial interpretation has been done away with the new code, where Section 38 mandates that before a workman is punished, certain rights are made available to him. Even if an employee is suspended, he has got rights in the form of subsistence allowance. Again, you will find subsistence allowance in the existing mechanism is only a state enactment. Only few states have such rights availed. Most of the states do not have any subsistence allowance law itself. Now, the labor court mechanism has been done away with. We do not have labor court designated courts once the new code comes into place. They are all going to be called only as industrial tribunals. Now, there is again no appeal provision. We have to ultimately go to the High Court by filing a writ petition. And the powers of tribunals and conciliation officers, you will find the same powers as today. Equivalent powers are being given in the new code. And again, this part is new to the labor law itself. As far as today we are concerned, the Industrial Disputes Act only recently brought in a 3-year limitation. Until 2012, we did not have even a limitation period as far as raising of an industrial dispute is concerned. You will find even after 12 years, 15 years, somebody can raise an industrial dispute. Now, that has been done away with by introduction of this new provision, which provides for a period of limitation. Now, you can't initiate a conciliation proceedings or you can't otherwise raise the industrial dispute after 2 years of the cause of action. Now, once the failure report, meaning the conciliation fails, failure report is issued, within 45 days thereof, you have to reach the court for conducting the case, as otherwise it cannot be done. Now, similarly, strike, I told you, there is a limitation period given, and powers to extend that by consent of parties. If both parties agree, a settlement is entered between employer and unions of workers, which provides for a consent even overriding these limitations. Such a provision, again, you will find there is a balance given there. Now, even before the tribunal, you will find these provisions are there. Within 90 days, the matter has to be disposed. Settlement is provided for. Now, you will find there are two types of settlements in the existing mechanism, what we call as the 12-3 settlement and the 18-1 settlement. 12-3 settlement is a settlement which is engaged in the tripartite method, meaning a matter is disputed, conciliated before a government officer, and before him a settlement is arrived. That is to be arrived at under section 12.3. And privately between the employer and a workman or a group of workmen, that is entered by virtue of section 18. So equivalent provisions are provided for as far as the new code is concerned. Now, certain things are made as offenses. Again, this you will find a new add-on provision in the new code is concerned. Section 193, please understand, false evidence or fabricated evidence which will lead to punishment. And then intentional insult. These are added on to the new provisions in the sense anything done in contravention to section 193 and 228 by virtue of any proceedings before the conciliation officer or the labor court, they will still be punishable offenses. As far as today's act is concerned, these provisions are not available. These are new to the code itself. Now, the new code did not look for any change in the existing disputes. They are protected. Since my time given was only 45 minutes, I follow a rule. I get up, I speak up, and I shut up when my time is over.
You can continue. You can take 10 more minutes, Ravi. You can take 10 more minutes, no problem.
Can I take 10 minutes?
Yes.
Yes, sir. Yes, sir. Try to summarize, sir, so that we can get more from you.
Judicial overreach by our principals, sir. So I take the liberty. Award under section 11A, certain powers are given to the labor courts while dealing with issues. Now, this again, section 11A is a unique provision as far as any judicial mechanism is concerned. Now, please look at any trial is concerned. Before you go to the court, you pray for relief. You say, this is what I want. This is my rights which are affected, and therefore mold my relief like this. In a criminal case, the mandate of relief is provided for by law. The Indian Penal Code says if this is the offense which is proved, this is the punishment which is going to lead. Now, courts are not empowered to mold anything beyond that, neither in a civil court nor in a criminal court. But however, section 11 is a unique proposition. Suppose a terminated workman for a punishment goes before the court saying my punishment is excessive. The court is empowered to modify the punishment. It can say termination is an excessive punishment, reduce it to something else. So this is a unique provision. Please see the vision of the framers even as early as 1947. They thought such powers are to be enshrined to a court of law. So this again, as I said, conciliation is a unique mechanism under section Industrial Disputes Act 1947. Section 11A is a unique mechanism where courts are empowered to mold relief by itself. You will again find any relief can be granted during the pendency of a dispute. This again will be the change as far as the new code is concerned. Materials on record. This is a practitioner's nightmare as far as the existing mechanism is concerned. That remains untouched even in the new code. An award of a court will become effective on the expiry of 30 days. Please see, this again is a uniqueness of the Industrial Disputes Act. In no other law you have that. For example, a suit is decreed, judgment is rendered. There is no effective date. On the date when it is rendered, it comes into effect. Of course, there is an appeal provision. Similarly, in criminal laws, today the sentencing is done. The convict has to undergo the sentence. But as far as an award of an industrial court is concerned, it comes into force only after 30 days of the award itself being passed. So this again is a unique provision as far as Industrial Disputes Act is concerned. Now then executionary provisions is brought in. Of course, this is equivalent to the earlier amendment to Section 33 itself in the Industrial Disputes Act. Monetary relief computation petitions can be filed where cases where only the substantive right is already available. Suppose a workman is not paid wages, he can go to the labor court and ask for wages under Section 33 capital C2. A similar provision is given for new code also. This is again the existing mechanism. And these are finer aspects of the law itself as to what is the definition of layoff. And in case of layoff, what is to be done. Most of these mechanisms have remained untouched. It defines as to what is retrenchment. The famous Sundaramani's case has to be remembered. Anything you do to remove a person will amount to retrenchment is the definition. Is also the legal interpretation for the definition. So certain rights are made available as far as employees are concerned in the form of retrenchment compensation. And then there are this finer rules of last come first go rule and re-employment of retrenchment. These are the existing mechanism. Again, that is adopted in the new act, new code. Closure of an establishment is also provided for. Again, you will find most of the commentaries that are made on the new industrial relations code is concerned. Now, the Industrial Disputes Act has two chapters, Chapter 5A and Chapter 5B. Now, Chapter 5B is applicable to establishments which have more than 100 workmen. 100 or more is the expression used. So anything you do to touch the workers' rights, and if your establishment has more than 100 workers, you always needed government permission before you could do that, meaning otherwise called as condition precedent. Now, therein a touch is made that instead of 100, now Chapter 10 of the new code provides all other rights which are similar to Chapter 5B, which is existing, but except the number 100 is tinkered to number 300. Again, you will find this act is very unique in the sense the definitive provision under Section 2 defines what is an industrial establishment. But again, the same expression is given a new definition as far as Chapter 5B is concerned. Therefore, one act having one expression with two meanings is again the uniqueness of Industrial Disputes Act. And there are certain things called as reskilling fund has to be created by the employer. This is in respect of the protection given to workmen. Offenses and penalties are given for. The value of 10 lakhs also is new to this act, and repeated violations will lead to these kinds of punishments. Now, the present Industrial Disputes Act has 4 schedules. Now, schedule number 2 and 3 is the most used by practitioners, and the 4th one is about unfair labor practice. Now, all the 4 schedules are removed in the new code, and they are making changes in respect to the first schedule, which speaks about the standing orders, second schedule about the unfair labor practices, third schedule about the conditions of service, jurisdiction of labor court and industrial tribunal, which is the schedule 2 and schedule 3, they are removed. With that, I will conclude. Broadly, within the given time, I have attempted to cover as much as possible, and I have not given any wisdom to you. These are only information given. Only on repeated application of all this information can lead us to claim some sort of knowledge into it. Now, these slides are not to be meant to be used as some sort of a reference tool, maybe for writing exams, but not as a practitioner's point of view. That is the word of caution I give you while doing this. If I've made errors in what I said, human being, I am prone to errors. I learn every day. The numbers given, pointers given, as much as possible, I have taken care. But all the more, I can still err. Please pardon me if I have erred. I come from Vivekananda College. And therefore, you take it that I am prone to errors. Thanks for this opportunity, sir. Your introduction itself was a big honor for me. I am always willing to be part of Vivekananda College's roadmap, anything that it does. Raghavendra was my 1 year junior to me, and we have had a lot of conversations during our years there. I don't forget all that. As I told you earlier, I still have my class notes, which I have taken in 1994, 95 and all that. I still preserve that in posterity. Thanks to all of you for patient hearing. If there is any questions, please put it to me.
Thank you very much, Mr. Ravi. Thank you very much for your insight, added with your experience to the changing scenario of the new labor legislations. So let us take few questions, with your permission, please.
Yes, Raghavendra, please.
Yeah. Pradyumna B. Ravi, can you please unmute and ask the question? Okay. See, Pradyumna B. Ravi asks, though the central government proposes to replace existing labor laws with a comprehensive labor codes in order to simplify and modernize labor regulations, the major challenge in labor reforms is to facilitate employment growth while protecting workers' rights and its implementation. What do you say, sir?
We can look at like this. Please revisit again to my earlier observations. This is a common misconception. The objects and reasons of any act is fundamentally the guiding part. Unless we read that, we don't get to understand what it intends. We don't, as lawyers, go by what newspapers write or WhatsApp commentary is given. So we don't go by that. Number one, comprehensiveness. Yes, that is one of the intention. To simplify and modernize, no, that's not the expressions used in the code. Nowhere it is used. They are not trying to simplify something. You can't simplify law because it touches upon rights of individuals. There is nothing called as a simple right. The resultant right may be simple, but the attempt of law is to empower you, and therefore it can't be simple. Modernize. We don't understand that expression. When can you call something as modern? Is it from the year 2000? Y2K bug came and therefore we became modern. There is no modern science. There is no modern medicine. There is no modern law. That is why we say law is not static. It is always dynamic. Every day there is new interpretations. Every day the attempt is to focus to bring in changes. And therefore there is nothing called to simplify and modernize. These are common expressions that is used. Lawyers don't use that. Then your point is, the major challenge in labor reforms is to facilitate employment growth while protecting workers' rights. You have made an observation, that is not a question.
Yes.
I subscribe to your view on
that. Thank you, Ravi. We have Rohit S. Swami. I think he has a lot of questions. He has added certain things. Mr. Rohit, can you unmute yourself and
yes, sir.
ask the question?
I go on the reverse. Rohit asks whether new labor code has further strengthened workers' rights and collective.
Yes.
This is to be time tested in the sense, the effectiveness of a law is only in its practice. The benchmark is set. It is, after all, some sensible discussion has gone in. There are these law committees which has sat into discussing each of these provisions. It is easy for us to sit on the other side and start picking holes in it and saying, why haven't this not be used in this particular sense? It could have been replaced with another word. Now, the framers take into all this into consideration, and then it goes to the parliament, and depending on the strength of the parliament, depending on the kind of questions that is posed and clarifications that is asked for, all these after a law is enacted and brought into force. Therefore, such discussions have gone in already. It is open for us practitioners now to test its efficacy in a court, when particularly a substantive right of an individual is affected, when his monetary rights, procedural rights are affected. You go and test that law, how effective that is. Therefore, it is too early, or otherwise, but it is presumptive of me to tell you it is going to be effective. It is to be time tested, will be the answer. And then there is a question, what are the compliances required by the employers under labor law? Are there any changes in the compliance by the employer in the new code? Is asked by Renita D'Souza. Ma'am, you have to go to a lawyer's office if you are a student now. Get to do an internship for 6 months at least. And then you will realize that it is too short a time for me to answer that question itself. But if you are already practicing lawyers, you know the answers, you are only testing.
B.V. Bellad asks, is the concept of negotiable agent is similar as that of recognition of trade union by the employer in earlier legislation, or has any different perspective?
Yes, sir. So my first suggestion is negotiable agent is not an expression that is used in law. I don't know, where did you find it? Please revisit. Negotiating could be the expression used. Again, agent la counsel. It's a representative capacity. If you look at, like, in a family, father has number of children. Among the children there is dispute. There is always no one voice. Each one picks up a hold of the father to say, you have to side with me. Father has a difficult task of siding with one child versus another. Similarly, as an employer, if there are more than one unions coming out with several demands, it's not so easy for the employer to discuss all of them and look at one versus the other. It is not one versus the other. It is together. And therefore, it was found necessary that a council and the election mechanism for the council itself has to be legislatively mandated. And therefore, there is one voice to speak at, one voice to address. So that is the necessity for this legislation change itself.
Thank you, sir. Our Professor Bolla, sir, has your question. A very good articulation with insights into the comparative analysis. Contract clauses was held unconstitutional as it is against public policy. Do you see any changes in the new code? He's talking about the contract clauses.
Professor is asking a question. Therefore, if I am to take what he intends asking me is, fixed term employment is one contract of employment. I need a bit of elaboration, as otherwise it will be very, I will only be misleading everybody. Fixed term employment, there is a contract of service, which is new to the code itself. Earlier it was not there. By stating that it was held unconstitutional or against the public policy, is that pertaining to the labor law that Professor is speaking about? Can Professor Moore?
Yes, sir. Actually, in Central Inland Water Transport.
Sir, you can unmute yourself and speak.
Yeah, I unmuted.
Yes, sir.
Yes.
Please, sir.
Please
Continue.
Please go
Am I
ahead, sir.
audible?
Yes,
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 sir.
yes.
In Central Inland Water Transport Corporation Brijanath Ganguly case, the Supreme Court was describing the contract clause which enables the employer to terminate the services with or without notice as a contract between a tiger and a lamb. And what is happening in reality is that the so-called hair and fire is continuously happening even at the with the advent of COVID and such other situations. The employers have been, maybe that they are forced to take such decisions. The contract clause has been utilized indiscreetly. And I want to know whether the new code permits such contract clause utility, and or is it taken as an unfair labor practice?
I fairly get your question, sir. We have to look at section 200BB. That is the provision. I think professor is referring to that when there is a contract of employment and the term of employment comes to an end, you can fire him. That's the tenure-based employment. And a slight tinkering is done by including in the definition as to what is called as the fixed term employment. Now, I as an employee, when I come in, I expect two things to be clear to me. One is, if it's going to be tenure-based, if so, clearly narrate, as far as the employer is concerned, this is what I look forward to. Clearly narrate to me as to it is going to be tenure based. Therefore, I will take a conscious decision whether I am to be part of it or not. Now, if I am informed that, and then I take a conscious decision, yes, it's going to be time bound, I become part of the employment. And when the term comes to an end, I question that it should not be tenure based. That's unfair. But look at the other point of view. What professor is pointing out is that it has become the order of the day that every employer engages at random, throws the workman at random. Suppose tomorrow morning I don't like somebody's face, I throw him out. He is asking whether is there any protective mechanism as far as such random throwing out is concerned. This is the much I understand from professor's question.
Yes, sir, indeed.
Pardon me if I am wrong.
Yes, sir, it's indeed.
Correct. Now, the protective mechanism is this. The judicial interpretations help us. I refer to the Sundramuni's case where any termination amounts to retrenchment, and therefore, for retrenchment, there are certain benchmarking, in the sense control measures. If it is for termination for a misconduct, rule of adi alterum partem comes into play. Rights are available. The workman can defend himself in the form of various rights as far as the domestic inquiry procedure is concerned. Now, as otherwise, he can only raise a dispute. You will find the injunctive mechanism is not provided for in any labor law. For example, the present Industrial Disputes Act doesn't provide for any injunctive relief. Suppose a workman has the threat of being removed. He can't go to the civil court and ask for interference. Now, if that question is to be extended by asking, is such injunctive provisions enshrined in the new code? My answer is no. The mechanism existing is only strengthened in the form of adding a mandatory provision for conduct of domestic inquiry, in the form of bringing in the definitive term of what is fixed term employment, in the form of monetary relief being granted to such employees. So some protection is given. I don't mean to say all the protection. What you would be looking at ideally is an injunctive mechanism. Before terminating me, I go to a civil court and ask for injunction, restrain the management from terminating. That is not open as far as we are concerned. Even in the new code, they don't speak about such injunctive rights. This collective, I think I fairly answered Professor's question.
Yes.
You're right, sir. Actually, the thing is that what is expected for to be more protective and effective for the labor, there ought to have been no unfair labor practice permissible through the new code. That much if it is guaranteed. There is a possibility that for the workers or working class to feel protected. Otherwise, there is scope for exploitation, and everybody can't be going to a court to get the remedy possible.
The simple answer there is, sir, the protection is in the form of making that as a punishable offense.
Yes.
If in an industrial dispute, a court comes to a conclusion, yes, there is unfair labor practice adopted by management, there is this criminal provision or criminalizing unfair labor practice. Such protection is given. Again, your question can still be, what is that an employee will get if the worker is, management is punished? For my substantive right as an employee is affected. I don't have the fun of sending my employer into jail.
Yeah, that's correct.
Points are still debatable.
Nobody likes to send that, but he wants to be protected. The working class must have that protection, because you are a weak person, you are losing the employment, and at that juncture, if there is a possible protection by law.
We are bordering on political theory. We are looking for absolute right. Permanently bring in a provision, there shall be no termination. Sir, we will go back to 1947. We will not be going ahead in time.
Mr. Ravi, just Mr. Jaishankar Whiteley has raised his hand. Mr. Jaishankar, can you please unmute yourself and can you ask the question?
Jaishankar, please.
Mr. Jaishankar, please. Okay.
You can conclude.
Yes, sir. I think you have answered most of the questions. And fixed term employment, there were some more questions anyhow. I think we should.
I have a query to ask.
Yes, please.
Last. Sorry. Thank you, Ravi Shankar, for a very good insight into the Industrial Relations Code. Of course, there are other 3 codes, which is a very voluminous also.
Sir, I'm sorry, I did not see your question.
No, I am asking the question now.
Yes, please.
The Industrial Code mandates that more than 100 workmen for a duration of 12 months, there should be a works committee. 1. Second is, it also mandates for more than 20 people, till 20 workmen are there, it should have a grievance redressal committee for addressing or redressing individual grievances. Okay. Do you think it is fair to have, why is it not unfair that more than 20 people, workmen are there, then only you should have a grievance redressal committee? And also, if it is more than 100, only you should have a works committee to bring about a harmonious blend between the employer and the employee.
More so as to why legal history has to be learned in law school. That's why 2 years we have history in law classes. Sir, when kings were ruling, sir, this is my opinion, because you asked for my opinion. This is my personal opinion. When these kings were ruling, whenever there was problems, all the problems come to the king. And they found mechanism of appointing ministers and other hierarchical officers before whom such problems could come to and addressed at their level and not to come to the king. Now, parliamentary democracy came. So we have this executive wing, which has several officers levels. Each of the dispute has to be brought in. It could be civil, criminal, whatnot. It could be a number of possibilities. Now, such hierarchical method, or otherwise we commonly call it benchmarking or control measures, are brought in even in laws as far as workers' rights are concerned. Now, absoluteness can't be looked at for any legislation. Third year of law, when we are introduced to Indian Penal Code, we always ask this question. Section 302 punishes a man with death if he commits murders. Are there not murders still happening? Regressively to look at, are we to either take a decision on scrapping 302 or not? Now, if we enter into a debate, Please see so many murders come by from 1860. The statistical figures would be so enormous. Therefore, there will be one group of argument which will look at the very same statistics and ask for reading out section 302 from the books itself. And there is this other set of argument. Please see, the numbers are so small, even if it is going to be in millions. And therefore, it has stood the test of time.
My thing, sir, my only request is, if there are people less than 20 people, workmen are there, then their grievances
are precisely I am coming to, sir. That's precisely
because the GRC is not there.
So looking at that too argumentative focus, coming to this point, now the expression employer is not defined with any number. The act or the code doesn't say somebody is an employer only if he employs so many. For example, take the Provident Fund Act is concerned. There should be 20 or more employees in an organization for the purpose of bringing into the force the act. ESI Act is concerned 10 or more. Gratuity Act is concerned 10 or more. Shops and establishments, no number is given. Similarly, you will find Industrial Disputes Act has no prescribed numbers. Even in the new code does not prescribe numbers. So they are looking at three criteria: systematic activity, cooperation of employers-employee for produce, goods or services. Now, if we are to look at a larger number or a smaller number, it is the framer's decision that it could be 20 as an average. Now, what is the legislative logic for choosing that 20? We may have to get into the debates itself, or the committee is working. I do not personally, I am not aware as to why they chose the number as 20. Now, the fair conclusion could be, in an establishment, if this many number of employees are there, give us them an extra layer of protection. It is not that there is no alternative level of protection itself. You can go to the conciliation officer, you can raise a dispute, you can join a union. But one add-on provision of mechanism is, hierarchically speaking, form what is called as a grievance mechanism. Address there first. Let us see whether that can be resolved. So one more layer of protection is given. This is the historical perspective that we can get from all these things. It has to be time tested whether it is effective or not.
Thank you, sir. Thank you so much. Professor Sudesh wants to know your opinion. Sir, can you unmute yourself and...
Yeah. It's okay. Thank you, Ravishankar. Since I've been teaching labor law for many years now, and then this new labor code comes, and there's all this news about it will be implemented. And
sir, you are also in authority, sir.
Not in authority. Sorry. So I just, since you're a practitioner also, is there a future for labor law in terms of whenever we speak about labor law, we speak about labor rights? Despite all the ILO conventions, recommendations, etc., being implemented through laws, these labor codes and all those restrictions, is there a future for labor law or labor rights? So my suggestion was, if we now start thinking in terms of making labor rights on par with international human rights, probably in coming days, we may see some sort of protection. Otherwise, capitalism is bound to destroy whatever was fought for. Your opinion, sir?
Again, sir, I just recollect from what I learned from my class in the jurisprudence lessons. There are these ought and is concept of law. Jurisprudence ultimately teaches us what is ought concept and what is concept. Again, harping upon political theory. Sociology as a subject itself. So the goal of law that the society ought to be this. And then there is this practical expediency, what it is to be dealing with. Now, you don't set benchmarks at, my pass mark used to be 40%. My pass mark used to be in school 35%, not 100%. Now, if we are to look at an ideal situation, yes, I subscribe to your view. It has to be at international par. No, but none of us argue to then say that ours is the highest standard and therefore the international community has to follow us. So that's not the way expediency teaches us. We are dealing with a particular situation. There is nothing called as anti-capitalism. My, again, personal view is communism is another form of capitalism. Ultimately, that is what would the political theory teaches. These are two different types of economic theories. There are one group which subscribes to this and another group subscribes to the other. Each one versus the other, not supplementing each other. So if law is to be made, if your question is that it should not focus on capitalism, it should destroy capitalism, I don't think we will be ever enacting any laws in that manner. We will only be trying to bring in laws. I use the expression we representing all the community, not personally, not I identifying myself into some group. That's not the expression I'm using. At the larger context, any law that is going to have, or I should say, every legal change that is attempted to be made has its economic impacts. One way or other, it is going to affect you and me. Let us remain or restrict ourselves at exercising our franchise and sending our representatives to the parliament. We are taught the moment you do that and they go sit there, we are evolving as a citizenry to even avail the right of recall. We dispute every law. It has become the order of the day. You will find any argument always has a counter argument. So therefore, we are not trying to look at an absoluteness as a situation. Art as a concept has to be reached. That has to be the goal, definitely. But ease is what we are dealing with. And therefore, this is where we are. When are we going to reach at international levels? Time will answer it.
Thank you.
Thank you. Thank you so much.
Thank you, sir. I think the moment for art has come now.
Okay.
Thank you. Thank you.
Thank you. Okay, Raghavan.
Thank you, sir. Thank you, sir.
Thank you.
I sincerely thank Mr. Ravi for your wonderful insight on the changing scenario of labor laws. Before I end the session, I request Pratibha Madam to share tomorrow's, next session, if you don't mind, please. Yes, the next session is on professional conduct and advocacy, which is going to be on 7/7/21. Same timing. I request all the participants to be there, present, and make that event a successful one.
Yeah,
So having said so,
Speaker Professor BL Vidya.
Yes,
Yeah.
Srimati BL Vidya, alumni of VCL, our college, and also she's a principal of Panchami Law College, Bengaluru.
Okay.
With that, I also note the presence of Dr. Judy Patil, Registrar Evaluation KSLU. Thank you very much, sir, for your presence today. I also extend my thanks to all the academicians and all the lawyer friends and alumni and the students. I express my sincere thanks to Professor KB Kempegoda, sir, and his team and technical team and all my friends. With this note, I take Mr. Ravi will take leave of this session. Thank you so